Hello, everyone. This is Compass, navigating legal studies for your mission. This video is for a legal essay practice. Today's topic is third-party practice and appellate procedures. Problem: City X in State A and City Y in State B are 15 miles apart. A bicyclist and a motorcyclist collide in State B, resulting in severe injuries to the bicyclist. The bicyclist sued the motorcyclist in the Federal District Court for the District of State B, invoking the court's diversity jurisdiction. The bicyclist is a citizen of State B, and the motorcyclist is a citizen of State A. The complaint alleged that the motorcyclist's reckless driving caused the collision and sought $300,000 in damages. The motorcyclist immediately contacted her motorcycle insurance company, claiming the policy required the company to provide a defense and indemnify her for any liability. However, the insurance company denied her claim, asserting that she had breached the policy terms by failing to report prior traffic violations. The motorcyclist argued that she had disclosed all required information and that the denial was unjustified. The motorcyclist filed an answer to the bicyclist's complaint in the District of State B. At the same time, she filed a third-party complaint against her insurance company, naming it as a third-party defendant, and asserting that the company must defend and indemnify her. She served the insurance company's registered agent at its headquarters in State A. The insurance company moved to dismiss the third-party complaint, arguing that A, it was not a proper third-party defendant under the federal rules of civil procedures, and B, the court lacked personal jurisdiction over the company because it had no contacts with State B. Questions. 1. Is the motorcyclist allowed to include the insurance company in the lawsuit as a third-party defendant? 2. If the motorcyclist is permitted to involve the insurance company in the case, does the court have personal jurisdiction over the insurance company even though it lacks any connection to State B? 3. What steps, if any, could the district court take to enable the motorcyclist to immediately appeal its decision to dismiss her third-party complaint against the insurance company? Should the court take such steps? 1. Can the motorcyclist file a third-party complaint against her insurance company in the pending lawsuit? A defendant may plead a third party if the third party may be liable to the defendant for all or part of the plaintiff's claim. However, the third party's liability must derive from the primary claim, meaning it arises from the same set of facts as the plaintiff's claim, for example, indemnification or contribution. Here, the motorcyclist's claim against her insurance company is based on a contractual obligation to defend and indemnify her for any liability arising from the bicyclist lawsuit. This is not a claim for derivative liability, but a separate contractual dispute between the motorcyclist and the insurance company. The insurance company's liability to the motorcyclist is independent of the bicyclist negligence claim. Therefore, the motorcyclist is not allowed to bring the insurance company into the action as a third-party defendant because the insurance company's liability is not derivative of the bicyclist claim. 2. Can the federal court in State B exercise personal jurisdiction over the insurance company? The federal district court may exercise personal jurisdiction over a third-party defendant if, first, the defendant has minimum contacts with the forum state sufficient to satisfy due process under the U.S. Constitution, or the defendant is served within 100 miles of the court which issued the summons. This is commonly known as the 100-mile bulge rule. Here, although the insurance company lacks general minimum contacts with State B, it was served within 100 miles of the district court, which issued the summons. This enables the district court to assert personal jurisdiction under the 100-mile bulge rule. Additionally, specific personal jurisdiction could be established because the insurance company's policy included a duty to defend the motorcyclist in litigation by providing coverage for incidents occurring in State B. The insurance company purposefully availed itself of the benefits and protections of State B's law. This constitutes purposeful availment, as the company could reasonably foresee litigation arising from such accidents, thus creating sufficient connection with State B. Therefore, the district court may properly assert personal jurisdiction over the insurance company, both under the 100-mile bulge rule and because the insurance company's territorial coverage reasonably implies that the company has minimum contacts with State B. 3. Can the district court allow an immediate appeal of its dismissal of the third-party complaint? The district court may direct the entry of a final judgment on one claim in a multi-claim case if there is no just reason for delay. Alternatively, the court is permitted to certify an order for interlocutory appeal if, first, the order involves a controlling question of law, second, there is substantial ground for difference of opinion, and 3, an immediate appeal may materially advance the litigation's termination. Here, the dismissal of the third-party complaint resolves a distinct claim against the insurance company. If the court determines there is no just reason for delay, it could enter a partial final judgment. Alternatively, the court could certify the order for interlocutory appeal because the jurisdictional issue is a controlling question of law. However, allowing an immediate appeal may not significantly advance the resolution of the bicyclist's primary claim against the motorcyclist. Therefore, the district court could certify the dismissal for immediate appeal, but it should carefully consider whether doing so would serve the interest of justice and efficiency in the litigation. Let's wrap up this session by revisiting the key rules. A defendant may implead a third-party defendant only if the third party may be liable to the defendant for all or part of the claim asserted by the plaintiff. This means that the third party claim must derive from the primary claim, establishing a direct connection between the liability of the third party and the defendant's potential obligation to the plaintiff. For personal jurisdiction, the Due Process Clause requires that the defendant have sufficient minimum contacts with the forum state such that maintaining the lawsuit in the state does not offend traditional notions of fair play and substantial justice. These contacts must arise out of or related to the defendant's activities in the forum, ensuring that the defendant could reasonably anticipate being hailed into court there. Interlocutory orders, such as dismissals of third-party claims, are generally not immediately appealable. However, the district court may enter final judgment on certain claims if they are distinct and separate from the remaining claims, allowing immediate appeal. Alternatively, the court may certify an interlocutory order for appeal if it involves a controlling question of law and there is substantial ground for difference of opinion. If the court determines that resolution of the issue would advance the litigation's ultimate resolution, it may choose to certify the appeal. Thank you for watching. See you in the next video. God bless you.